appeal before this court on a matter of agency, and this matter turns on the infringement of constitutional rights and the harm that would befall, and the harm that would ultimately befall the applicant is real and imminent, pending the ruling that is seeking before this court. The possibility is that the applicant would suffer in this matter. The possible prejudice that the applicant would suffer if this matter is not afforded the agency requires is that the applicant may be subjected to a ruling which is not appealable on its merits. Outside of that, my justices, we seek or rather, accordingly, the applicant seeks a deterrent order in relation to Rule 8 of Chapter 4 of the Rules and Regulations, as it is unconstitutional, and my learned colleague will expound further on that particular point. And accordingly, we seek to review and set aside the further continuation of the disciplinary process by method of arbitration. If the court would permit, I'd just like to set the background of the matter before proceeding to the merits of the case that I'll be arguing. In June 2022, the respondent announced the implementation of testosterone regulation, which had the effect of affecting certain female swimmers and the effect of actually preventing those swimmers from participating in the sport of swimmers unless those swimmers had medically suppressed their testosterone levels. The applicant in this matter was outraged by the exclusion of these other swimmers and expressed their displeasure through social media and other local media. The applicant's expression of frustration was met with impunity from the respondent, and as a result, disciplinary proceedings were initiated against the applicant. And in those disciplinary proceedings, the applicant had allegedly transgressed Rule 8 of Chapter 4 of the South African Federation of Swimming Domestic Rules and Regulations, which read as follows. Rule 8.1 says that persons subject to these rules shall not act in a manner that is likely to affect adversely the reputation of the South African Federation of Swimming or the sport of swimming generally, nor shall they act in a manner that is likely to bring the sport into disrepute. And 8.2 says, persons subject to these rules shall not publicly criticize or in any form or manner denigrate or make any negative statement or give rise to any negative inference in respect of the subs or the sport of swimming generally. Our submission is that the disciplinary proceedings that are initiated that are initiated by the respondent serve the purposes of violating the constitutional right of the applicant, and that the following rights are actually violated. The sections 10 right of the applicant being the right to dignity. The applicant is going to be subjected to an unfair and punitive disciplinary process because the applicant has expressed a negative view in relation to the conduct of the respondent. The section 16 right of the applicant, which is the right to freedom of expression. The applicant is actually being purged by the respondent for views that she has held and expressed about the regulation that the respondent seeks to enforce. Section 33, which is the right to just administrative action, which is actually the decision that is taken by the respondent to discipline the applicant, and that decision itself constitutes administrative action. And lastly, section 34, which is the right to access courts, and the respondent seeks to arbitrate the constitutional infringement between itself and the applicant, and thus this would deny the applicant the ability to have this matter adjudicated by an independent tribunal, being this court. The issue that this court would have to decide is whether or not the issues that are raised by the applicant are of a constitutional nature and in the interest of justice enough to warrant the adjudication by the justices of this court, and whether the respondent's rules violated the constitutional rights of the swimmers. And lastly, whether Rule 10 qualifies as an internal remedy for the purposes of quiet. In dealing with the merits, my justices, the question that I'd like my justices to ask themselves is, does the constitutional question that is raised in this dispute dictate that only this court, can adjudicate upon this matter? And to that, Chief Justice Kings in the third case and legal impeachment case of 1918 said that courts of law exist for the settlement of concrete controversies and actual infringements of rights, not to pronounce upon abstract questions or to advise upon differing contentions, however important they may be. The Chief Justice then left us with the thought that it would do us very well to adhere to the principles that are laid down by the long line of decisions namely that a declaratory order cannot be claimed merely because the right of the claimant has been disputed, but the such claim must be founded upon an actual infringement. That infringement, my justices, is on section 16 of the Constitution. And any rule or conduct that serves to obscure or limit the applicant's section 16 right means that the constitutional rights of the applicant are limited. While the right to freedom of expression is a fundamental right, the courts have held that it is not a paramount value unless it is interpreted in the context of the values within the Constitution. And to that, we contend that the conduct of the respondent has actually violated the applicant's value and rights to human dignity. The value of dignity that is based upon the Constitution cannot be doubted. The Constitution asserts dignity, and human dignity therefore informs constitutional adjudication and interpretation at a range of levels. With that said, I would actually like to make a concession that the applicant today does not dispute the fact that there is a valid arbitration agreement between the applicant and the respondent. But with that said, the disciplinary proceedings that the respondent seeks to take are actually they turn on a constitutional matter, and as a result, that dispute cannot be referred to arbitration. And for that, I would actually like to refer the court to Section 3 of the Arbitration Act, which informs us that unless the agreement otherwise provides, an arbitration agreement shall not be capable of being terminated except by consent of all the parties thereto. Subsection 2 says, the court may at any time, on the application of any party to an arbitration and on good cause shown, set aside the arbitration agreement, which is actually what we're here to prove to this court today. That view is then supported by Article 36 of the Ubuntu Model Laws, which states that the recognition or enforcement of an arbitral award, irrespective of the